Yeah. Um, I'm just doing this right now to go through uh the um as you probably know, the transcripts from the Richard Allen trial finally became available by sheer miracle. Um, but there's one hearing in particular, and it's a closed hearing. Um, that I was just very curious about because it's very telling. So I want, and so some of this is just me wanting to chat through and see if the Brain Trust has come up with anything regarding this, or if anybody has any thoughts about what is contained in this previously sealed hearing. And so, this is the kind of thing that we need, is to understand what went on behind closed doors. So to set this up a little bit, this is a from the transcripts that were released yesterday by Carroll County. Um, the and a previously unknown closed hearing was made public through these transcripts. And this one is giving me stomach ache because I don't know, and I don't want to make this about a particular outlet or media peddler, but as many of you know, I've been very, very critical of the way that Anya Kane and Kevin Greenlee have comported themselves over the course of the Richard Allen trial, in regards to their journalism, etc. And I had some, in the words of uh, Judge Bev, grave concerns about some of their sources that were really struck me as very odd. Um, and now it seemed to me that there was a lot of shenanigans behind the scenes there. And I want to be clear, it's one thing to have a source, it's another thing to have a direct line to the state to push a narrative and to also do things that potentially run afoul of professional ethics. So when I saw this yesterday and that there was a closed hearing, and this is in August of 2024, so this is pre-trial, obviously. And I found this very, very interesting. I don't know if people recall or remember when I spoke about, you know what I'm going to do? I think I'm going to read this first. So this is from closed hearing. So this is the record of status hearing held on August 23rd, 2024. Okay. And all of these are publicly available now. Thank goodness. So here's all our appearances. And then we have blah, blah, blah. Okay. So the proceedings start. And I'm just going to read this through and everybody just sort of make mental notes. Okay. So the court. All right. Well, good afternoon. We're on the record in the state of Indiana versus Richard Allen, 08C01-2210-MR-1. I'll show that Mr. Allen is here in person with his attorneys, Mr. Rosie and Ms. Auger. I understand Mr. Baldwin is tied up in another matter, so won't be able to join us. The state is here with the prosecutor, Mr. McClellan, and the deputy prosecutor, Ms. Diener. Thank you for making yourselves available for this hearing. I know it was kind of short notice. I want to highlight that kind of short notice. It makes me wonder, why was it kind of short notice? But that's okay. That's one of those making a mental note. And I know everybody's really busy, but I want to know that we had an issue that we kind of left hanging at the end of our hearing. And I think this was a 3-day hearing that was in the end of July, right in the beginning of August. If anybody knows anything, please let me know in the doodly ding dong. I know everybody's really busy, but I knew that we had an issue we left hanging at the end of it. And I appreciate, one, that we had the forethought to schedule this hearing, and two, that we were trying to do it at 7 o'clock. We weren't trying to do it at 7 o'clock on the night of the last day of our hearing. I know when we were up here at the bench, everybody was very tired. It was an extraordinarily long day, as well as 2 days prior. So that was the 3-day hearing prior to the trial. So I appreciate that we all had the opportunity to get some rest and reconvene. I also appreciate our agreement that this portion of our hearing is closed to the public. I know we have members of Mr. McClelland's staff and members of Mr. Rosie's staff, but this hearing is closed to the public and to the media. And this is important as well, that it's closed to the media, right? Let's put a little highlight there. And I think that that's appropriate based on the nature of the discussions. I know we're having discussions up here at the bench, and it's really hard to do that and have any kind of privacy with 1,000 people in the courtroom. So I appreciate we had this opportunity. Mr. Allen, at the conclusion, again, this is still the court. Mr. Allen, at the conclusion of our hearings on July 30th through August 1st, I did have some concerns that I shared with counsel up here at the bench. Those concerns were about a statement that you had made to Dr. Walla. You're aware that your attorneys filed a motion to suppress the statements that were made. I think that motion was filed on April 11th of this year. Attached to that motion were reports that were provided by Mr. Rosie to the court from the Department of Corrections. I know there were reports by Dr. Walla, reports by other inmate guards, reports from, I know, the warden. I think there was a comment in there from a warden on page 84, the motion report, blah, blah, blah. Okay. I know in that interaction, I believe, given that information to counsel in an email. Okay. So she's referencing an email from counsel, and the counsel will come up here in a minute. The specific area that caused me concern, the court goes on, you expressed some frustration and Dr. Walla quoted you. Now, take that with a grain of salt. Dr. Walla quoted you in the report indicating that, quote, he felt his attorneys were not listening to what he wanted, such as him wanting to just plead guilty. Now that's in quotes, so I don't know how it was actually said, but I'm assuming that it was captured. I'm not sure how Goal stated it, but anyway, so I told the attorneys up here at the bench, Mr. Allen, that this statement caused me some concerns. The attorneys are very well aware the decision to plead guilty rests entirely with the defendant, with yourself. It's akin to or similar to a decision to testify at trial. That is our decision, only your decision. It is similar to a decision that you would make as to whether or not you want to have a jury by trial or by bench trial. Those are decisions you make by yourself with advice of counsel, but that is your decision to make. So your attorneys have a duty to carry out your wishes. So if you tell them that you wish to plead guilty, they have an obligation to make that happen. And that's what I shared with everybody up here at the bench. I know Mr. Luttrell isn't here, but he was up here at the bench, as was Mr. Baldwin as well. So I shared those concerns. I asked the state at that point if a plea agreement had been offered to you. Initially, it indicated that it had not. Okay. So at first, the state said, no, we haven't. But then Mr. McClelland indicated that he had made an offer. This is very interesting. I believe it was Mr. Rosie told me that it wasn't an offer. I think you referred to it as an angry email. Mr. McClelland stepped in and indicated, no, it was an offer. So the state again indicated that it was an offer. Are you aware, Mr. Allen, that an offer had been extended to you? The defendant. As of today, I am. The court. As of today, you are. Okay. So you weren't aware of it prior. The defendant. No. The court. Okay. So, Mr. McClelland, I asked you if you would please prepare that offer. And this is something I really want to know about, y'all. I asked if you would prepare that offer. How did she make that request to Mr. McClelland? I don't know. If you have that offer, I'd like you to read that into the record and provide a copy of that to Mr. Allen and his attorneys here in open court. Again, it's open court, but it's closed to public and media. So this is the first we're hearing of it. So Attorney McClellan, yes, Judge, the offer the state made via email, it wasn't a formal offer in writing. Okay, so here's where we start. It wasn't a formal offer in writing, but it was through an email. Is that the defendant agrees to plead guilty to the information charged in counts 1 and 2 of the murder, and that the sentence is left to the court in its entirety, and that if the court deems probation is appropriate, the terms and conditions of the probation be left to the court, that the defendant will have no contact with the victim's family, and that all fines, fees, and costs be left to the court as deemed appropriate. The state will agree to dismiss all the remaining counts. Court, has that been reduced to a formal offer, a written offer to the defendant? Mr. McClellan, yes, Your Honor, I brought that with me today in court. Do you want me to give you court a copy as well? The court, no, I don't need a copy. What? Okay. I want to make sure that Mr. Allen has a copy of that and his attorney have an actual formal offer other than an email. I understand as the offer is an offer in whatever shape or form that it is tendered. So thank you for providing that to counsel and Mr. Allen. Mr. Allen, you have now received the state's offer. Do you wish to plead guilty? Defendant, no, Your Honor. Court, okay, so you wish to proceed to trial. Defendant, yes, Your Honor. Court, okay, I would then ask that we recess this hearing so we can invite the public in if they wish, because there's only a couple of logistical matters we need to discuss on the record about the upcoming trial and at the court's availability prior to trial. Mr. Rosie, did you wish to make any comments or say anything or add to this record? Attorney Bradley Rosie, yeah, I have really kind of a question. I know, of course, though, about the context of all of this, and I certainly don't want to see a situation where, if Mr. Allen is convicted and there's an appeal, that somehow somebody comes in and says, well, wait a minute, his lawyers were ineffective. They didn't communicate an offer to him. And I'm thinking that is important to the court as well. I'm not trying to, suggest that that's why we're here today, but that would make sense. Again, what does this even mean? Let me highlight that. Mr. Allen indicated that as of today, he was aware of that, and I'm just reporting to the court. I had shared this email with him. It was probably a week or two ago now. I've lost track of time, but it was since we were last here. The court, okay. Mr. Rosie, I shared this email that I have from Mr. McClellan. The one that I referenced previously at the bench with him, let me read it. And he acknowledged that it existed. And so that is kind of the backstory on how we became familiar with this email. I don't want to get into a bunch of arguments today, but we were making a record. I didn't view this as a formal offer. I viewed it as two lawyers who were, exchanging blows over emails about an issue that was it was about an issue of your recusal is how it started, because there was a motion filed around that time. This email, so what he's referring to right here is this email from Nick McClellan is dated January 30th of 2024. Okay, this is important. I'm going to highlight it. Let's see. Okay. I'm just going to keep reading and then I'll come back to chat. Y'all just drop your questions in the doodah. I think you guys know where I'm going with this. Okay, this email is dated on January 30th. So ouch. So again, the closed hearing, right, is on the 23rd of August in 2024, so before the trial, and closed to the public. This email offering a quote plea deal is dated January 30th of 2024. And this is Mr. Rosie relaying this to the court. It's just eight months after the circumstance that you wanted to address today. I don't know what this is. So I'm just trying to clear the record on that. And the offer was made in an email that was basically, quote, if your guy wants to plead guilty, this will be over. He can plead guilty to 2 counts and I'll dismiss the other ones, end quote. Well, at that time, actually, there were only 2 counts. The state had filed a motion to amend the information about 2 weeks prior to this. I think sometime around that hearing we had in front of the Supreme Court in January. And Your Honor didn't even address the amended charges until I think March. If you look at the CCS, you'll see those dates. But I guess my point is being that the banter that was going back and forth as to about counts that had never been formally accepted as part of the charging information. And so I want the court to have some context in how all of this kind of unfolded as that backdrop. Okay, says the court. Mr. Rosie, yeah, the court. Ms. Auger, do you wish to speak? Attorney Jennifer Auger, no thank you. The court. Mr. McClellan or Ms. Diener? Mr. McClellan, I don't have anything on that topic, Judge, no. I do have a few other things I'd like to address with the court in this closed session on the topic, but on the topic of this plea. Court, okay. Mr. McClellan, it's been presented. If he doesn't want to accept or plead guilty, then the conversation is over and we'll move on. Court, okay. And in my experience with prosecutors, up in my jurisdiction is they put time limits on extended formal offers. Like 7 days prior to trial, the offer expires. 5 days prior to trial, the offer expires. So I don't know what your practice here is in Carroll County. Mr. McClellan, it varies, Judge. The court, okay. Mr. McClellan, I would say the offer's expired at this point. If Mr. Allen doesn't want to plead guilty if Mr. Allen does want to plead guilty at some point, the door is always open to talk about. The court, okay. Mr. McClellan, a negotiated offer. I never close that door, Judge. You know, if the court will accept an offer at the last minute and we can work something out, the state have done that on occasions as well. So, but at this point, I'd say the offer's closed. He doesn't want to plead guilty. If we need to come back to the negotiation table, we can do that. The court, okay, that's fine. All right. What else did you want to discuss? Let's see. Okay, so let's just stop there for un momento. So, hi everybody. So, does anybody have any idea why this is concerning to me in regard to well, actually, in regards to Nick McClellan, and I kind of thought about this a little bit, trying to think of how best to bring people up to speed. Yeah, so let me do this then. This is kind of, where's my sort of makeshift? Here we go. So this is kind of the way, and I'm just going to talk through this. This is something I kind of wrote up, but this is the timeline. And I think everybody here knows that I've filed an official bar complaint against Kevin Greenlee for several things, involving me, involving their contact with Mr. Allen as a represented party. We'll get to that. But also they're being listed on a false police filing with Nick McClellan and by Jerry Pullman. So in thinking about this, when I got involved with this case, it was purely because I thought that there was just many problems with the fact that there was no proper journalism going on in my experience. So, and that's how I kind of stumbled upon Murder Sheet. And as everybody knows, they sucked the air out of that case and took ownership of it. And I think that, again, reasons don't really fucking matter right now. But so if we go through the timeline, I want to go back to when Mr. Allen was arrested and how this sort of rolls out and how this pertains to this closed hearing and why it makes me a little sick. So Kevin and Anya went on some channel. I don't know what it is. It was on some Rumble. I'm not familiar with Rumble, but it was on some Rumble channel that they knew, and this was right after, this is in 2022, right after Mr. Allen was arrested, and they went on some channel and they said that they knew, they were alerted by a source that they trusted very much, very close to the case, or whatever the words were they used, and knew that there was going to be an arrest. They didn't know who, but they knew that there were going to be arrests. Okay, fine. Now, listen, some of this is just typical in the journalism space. You get a heads up, you get a whatever. But I think that that to me is the beginning of what became the pattern and practice of uh, the nature of what's contained in my bar complaint, which is still pending, plus the way that Nick McClellan seems to have shown his ass in this hearing that was until yesterday confidential. So 2022, we know Richard Allen was arrested. Kevin and Anya said they had a heads up about that. We also know that they got a hold of the Logan uh, warrant or whatever it was. So they had already started, and rightfully so, trying to get as much information about a huge story. By 2023, I am told that they are in constant contact with, or trying to be in constant contact with the defense team, peppering them with questions, et cetera, et cetera. And I think that this is around their reporting when, and I mean, again, reaching out to defense when they've been yeeted from the trial, whatever. But again, so they're and I have actually been made privy to some of these emails, and some of them are jump the shark a bit in my let's just put it this way. I would not utilize some of the tactics that they utilize, but whatever. So this is kind of ongoing, right? So they're building their story arc, and then let's see. Then on April 12th, and I did an entire video on this. On April 12th of 2024, Kevin and Anya. So April 12th, 2024, right? Picture that date, April 12th. They reach out to Mr. Allen, and they reach out to him when he is at Wabash, I think. He'd been just moved to Wabash. Let me see if I still have the actual document. Let me see. Let me stop this for a minute. Let me see if I had an actual. And the reason that this is concerning to me is that, well, I mean, there's a lot of reasons, but I think to me the reason that this is concerning at this point is because I think that it bears noting the potential for Mr. McClellan's over involvement with information. So, all right. And why can't I find it? Have you guys seen it? I'm like, have you guys seen this thing? Actually, let me see if I can pull it up separately, and then we can all experience it together. Please stand by. Okay, so let me see if I can. Is this the one? One moment. Yeah, okay. So let me share this. Yes, that's the one. So just so you know, this is what, and this is just an overview, and this was, let me put this on the screen here. Is that it? Is that it? Yeah. Okay. Um, okay. Let's see. All right. So yeah, this is something I did just sort of as a timeline, and I want to talk about the new revelation. So let's see. Okay. Yeah, so this is just when the media was trying to intervene to get any information, um, because, oh yeah, and the gag order, right? The supposed gag order. Okay, so this first point. So limited appearance was filed on June 8th, 2023, which is kind of neither here nor there. And they were Kevin filed in as a legal counsel. He's a licensed attorney in Indiana, representing their company, Mystery Sheet, Murder Sheet. So, and to get public records, and I get that, and that's totally legit. I mean, I was fixing to do it yesterday until until the floodgates finally opened. But so there's nothing weird here yet, right? But so let's keep going. Let's see what else happened. So okay, so this is the one. Um, this is the one that makes my tummy hurt a lot and got me also when I reported this the next day, basically they reached out to a former employer of mine. um, so and basically disparaged me, and so that's or made a misrepresentation to a third party. So that's when I filed the bar complaint. Because I'm like, no, you can't do that. So anyway, the point here is though, on April 12th, 2024, so prior to the August hearing, which was closed, prior to any mention of a plea or whatever the case may be. I mean, people may have been speculating. I don't know where the hell they were speculating, but all of a sudden they show up on April 12th, 2024, and reach out to Richard Allen and say, hello, Mr. Allen. And it's from Kevin and Anya Greenlee. So Rule 4.2 in the state of Indiana precludes any attorney reaching out to a represented party, especially when you're a party to the case. And as of now, April 2024, he was a party of the case, albeit as an intervener for public information, but we'll get to that. So this is a huge, this was my second complaint. So I made 3 complaints on the bar thing. The first was coming after me, which was bullshit. The second was this. Anyway, hello, Mr. Allen. My name is Anya Kane. I'm a journalist. I'm covering your case. I was wondering if I could ask you a few questions. 1, how are you today? 2, how is Wabash Valley compared to Westville? 3, what sort of things do you do to pass the time in there? It'd be great to talk to you about your case too, but understand if you don't want to. Just let me know. I'd mostly be curious to know if you're still going through a trial and use an actual innocence defense, or if you're looking to plead guilty and make a deal. All the best, Anya. How did they know? How did they know? Actually, let me see if I can play this, because now I'm just pissed. Because here's the thing. I reached out repeatedly to these people, Kevin and Anya, in good faith, because I'm like, look, man, I've been super critical of you, and I stand by every word, but maybe there's something here. Now, let me know if you can hear this. Can you guys hear that? Okay, stop. Hang on. You couldn't hear that? Okay, hang on. Let me try something. All right, hang on, hang on. Okay, can you hear me now? Okay, so this is a recording I made. You can't hear me? You should be able to hear me. Hello? Oh, okay. Got it. All right. So this is let's see. Let me go back to this. This is just an audio because this is okay. So I can't remember the exact date, but it was back, must have been, it was earlier this year. So March of this year, maybe. I reached out after I found out that they had called, or they had sent this message to Richard Allen. And this is, and I'm playing this because it's like, I guess I must have had some sort of weird feeling. So let me know if you can hear it.
Hi, this is Kevin Greenlee. I can't come to the phone right now, so please leave a message and I will return your call as soon as I can. Thank you. At the tone, please record your message. When you have finished recording, you may hang up or press 1 for more options. Hi, Mr. Greenlee. This is Andy Kopsa. I'm trying to follow up on several emails that I've sent you requesting comment on a contact that you and Ms. Kane had with Mr. Richard Allen on April 12th, 2024, asking him questions about his case and something about a plea deal or plead guilty. The actual information I'm looking for is what made, is there something that everyone is missing that made you think there was a plea deal in the offing? Also, you know, the problem, it seems problematic, at least somewhat, that there was a gag order in effect. Obviously, Mr. Allen has his First Amendment rights, but you know, the reaching out and the contacting a represented party to ask him about his case. Yeah, so that's all. I've been trying to get a hold of you because I've been very critical, obviously, of your coverage, but I'd like to hear your side. So let me play that one part again, though, because I think let me play this one part again. On April 12th, for asking him questions about his case and something about a plea deal or plead guilty. The actual information I'm looking for is what made, is there something that everyone is missing that made you think there was a plea deal in the offing? Also, yeah, so that's the question that I asked, and I was going through
So I was going through my notes and things, and I record, and but I think that we have I mean, I think I have my answer. Honestly, because, you know, to me, let me just go back here. Toots is executive producing. I think she's up on top. I mean, okay. Yeah, hang on. So I called Nick yesterday. I mean, I reached out and I called and I left a message. He's not going to call me back, but that's because I wanted to ask him about this hearing. Let's see. So the date of the hearing, I'm going to put it back up here. One moment, please. Let me make sure I can find it. Where'd it go? Dang it. One moment. It is from all right, so it is from, let me make sure I can put this back up. It's actually volume 7, page 78, if everybody wants to take a looky-loo. So yeah, you see that. So yeah, so it was on the 28th. I'm sorry, the 23rd of August. So this is the status here. It was a status hearing that was closed. So it was closed. It was August 2024. Okay. So when I saw that yesterday, I'm like, that makes sense. That makes sense. That makes sense. Now, it's one thing to have a law enforcement informant or feeding you information. I can't say who it was, but I suggest that there's a decent circumstantial case there to raise questions about, was there any communications that happened about a quote plea deal? Because I remember hearing it at the time and I'm like, why did they think to ask him about a plea deal? That's fucking weird. And I just was like, certainly they didn't come up with that all their own. I think I may have even said as much out loud. So the problem, I think that it's concerning among the laundry list of concerning things. So yeah, so apparently there was some sort of, and I don't believe from reading this and from, I was talking to Osbrook and Weineke yesterday. I had run some of this by them about this sort of quote plea deal. And the bottom line is that there really was no plea offer. And I think Mr. Rosie establishes a pretty decent record here of saying, yeah, that was kind of just a missive from Nick McClellan, sort of being a jerk. And yeah, that's not really what he intended. I do think that there's room for sort of interrogating why uh, why it took him so long to get to it, but I digress. Right now, it's like my focus is on the state and what the state may or may not have done. But I think that there really was no plea offer per se, but now we have evidence on the record that McClellan sent an email to somebody, I guess to Mr. Rosie or Baldwin or whoever it was, and said, hey, if your guy wants to plead guilty, right? So the big takeaway for me is, how did that information get to a media outlet? And not just that, because that in and of itself may not be a big deal. But, and I'm speculating and I am for instancing and allegedlying, this is for educational purposes only, but let's do a thought experiment, right? What then leads a news outlet, a media outlet, a podcast of any stripe to reach out to a represented party? Oh, by the way, while you're a barred licensed attorney in that very same state, and you know very well 4.2 precludes that very explicitly. And you're also on the case, meaning you are a party to the case, as I showed you in that 2023 filing. He never signed or never turned over a notice of completion to the court. So he was still getting notices. Kevin Greenlee was. Now, this brings me back to the later part of this. Yeah, I know. I mean, but I mean, my point is this. My point is, I don't want to get bogged down in that part of it, in the like, oh, the plea deal of it all. The thing here that I'm trying to hone in on is, was there misconduct? Was there something that rose to a level of misconduct on the part of the state, whether, no matter what form that took, if it was a prosecutorial thing or if it was a law enforcement, whoever was acting as the state, right? Because the state is all of that. Was there some level of misconduct? And if so, what does that mean? Right? What does that mean to all of in all the other nonsense in this case? So that's the thing I'm trying to drill down on, is that Nick McClellan sent an email, hey, your guy should plead guilty plea. Well, if your guy wants to plead out, whatever. I'd love to get a hold of that email, Mr. Rosie, if you want to send it. But that's out there. Then April 12th, and keep in mind that this is right before April 12th, 2024. The trial was originally scheduled for May, I think. So it would have been roughly the eve of what would have been Mr. Allen's trial. That Murder Sheet contacts him and asks, hey, do you still want to go with actual innocence? Do you want to plead guilty? Do you want to make a deal? And I called and followed up and said, where'd you get that notion from? And of course, they went ahead and just sent a stupid letter to a former employer of mine. What would possess somebody to do that? Was it strategic? Was it trying to just be? And I think the other thing to keep in mind too is that they never disclosed that. So on future podcasts, they reached out to Kathy Allen when all this news or whatever was out there about her potentially, you know, uh, divorcing Richard Allen. And again, this was in September, at the end of September, at the end, right before what became his trial. So again, they're contacting him right before he goes to trial saying, hey, do you want to divorce you? Does your wife want to divorce you? My point here is that they disclosed that conversation. They disclosed that they reached out in that conversation in their podcast, and you can go look it up. But they didn't ever disclose to their listeners, to anybody, that they reached out to Mr. Allen, asked about his plea. And I always found that to be very telling. So there's one last thing that I want to point out here, and then I'm going to go because I'm tired and grumpy. But there's one other thing here that Nick, and again, this is volume 7, page 78, it starts, if you want to read it. Let's see. Remember when I said that, you know, there you can file as an intervener? And I was talking about how I was fixing to do that yesterday until, you know, all the transcripts were released. There is a part in here, damn it. Ah, here we go. This is where Mr. McClellan gets on his high horse again, on page 95. Let me just begin this. Damn it. Frustrated. It's starting to get warm. Okay. So this is later in that same day. So August 23rd, 2024, closed hearing, whatever. Okay. So, all right, Judge, one other thing, Mr. McClellan says. Court, yes, sir. Mr. McClellan, it made me think of something when you said about if the defense is going to file something confidentially so that an attorney, so the state can see it, and I appreciate that. One of the recurring problems the state gets notice weekly is that the continued leak about this case and discovery being leaked and those kinds of things. And I think part of the problem is that we've got several attorneys still on the case as attorneys of record. Kara Weineke, Mr. Osbrook, there's media, Hennessy. Are those attorneys still necessary? Do they still need to be involved in the case? Attorneys for media groups are still there. Blah, blah, blah. I want to point out something here, is that he went, the narrative of the leak, right? The narrative of the leak and who's a party to the case. And to be fair, Kara and Michael and Hennessy, and there was the Megan Carpenter, was it Megan Carpenter, who signed on to try to get the transcripts, whatever. The idea that he name checks Kara, who brought the original action, right? Who was a part of, like literally, actually a part of the ongoing case, who also filed her notice of completion by this time. And if McClellan knew or should have known that she was no longer on the list, that Michael Osbrook was also working with attorney Hennessy, who were defending the defense team from their contempt hearing. But then there's all of a sudden, oh, this media? What about Kevin? Kevin was named on there. Why don't you mention Kevin Greenlee? In the same, like, I mean, does he not know Kevin Greenlee? I know he does. He's interviewed him. Oh my God, they've had a real good time. I'm sure that he's in the book. I'm sure he's in the documentary, whatever. Nick, stop it. Perpetuating, even in a closed hearing. I just was like, you gotta be kidding me. You gotta be kidding me. Really? So I think it's a couple weeks after that. And I put this is all somewhere on my channel somewhere. But Gull finally yeets everybody from the case. But here's the other thing, too, that everybody needs to understand when Nick says something like this, as stupid as this, right? Is that when you file something, you can click on and off parties when you make a filing. Everybody's there. Even when you file, like when I went in to go file pro se for the transcripts before they were magically released, thank you, cranks, it listed all the interveners. I mean, you know, NBC Universal, Twist Media, blah, blah, blah. You can select who you want to be noticed or served or receive notice. So Nick knows that. If he's so all fired up and worried about who's getting noticed on what, I don't know. Click. Right? I just, the alacrity with which this man just, so that was confirmation to me at this point, was like, okay, so there might be something to that whole thing. And not about Murder Sheet. Go with God, you two, right off into the sunset. But with Nick McClellan and the state of Indiana, I want to know, and everybody should want to know, right? Everybody should want to know, what the fuck? And this, again, is just one of the many issues. Is it an issue behind the scenes? Is it an issue that's going to do anything to move the needle on Mr. Allen's case? I mean, probably not. But certainly, it's of grave concern, again, to use a Bev phrase, right? So, I mean, that was kind of it. That's really kind of all I wanted to mention, because I've been kind of thinking it through here. I've also just, one other thing, I've looked into getting the audio, and I know there was some back and forth on Twitter and about who can have access to audio. And I'm still trying to sort that out. I talked to, I mentioned something to Kara about it, and Kara and I kind of talked about it a little bit. And I think that the reason that Andrea Burkhart was denied, and again, I got to go consult with with actual lawyers. But I think it was because Andrea appropriately asked for access to the audio recordings under APRA, which is basically like FOIA for Indiana. But Gull cited, and I think appropriately, Rule 74 of the trial rules. Now, there is no trial anymore. So she cited that as a reason, or as her authority to be able to deny access to those audios. And I may not be understanding it completely, but this is sort of the conversation that I had. So yeah, so I think there may still be a way to get access to the audio, because it seems to me that that would be absolutely necessary. Because I do think that there's actually some case law out there about discrepancies in transcripts and audio recordings that have been broached in appeals. So anyway, it's just something I'm thinking about, reaching out to Carroll County and seeing if they can release that stuff. But so that was it. Just wanted to go very, very briefly. I'm very tired. It's getting hot. And let's see, where's Toots? Oh, there she is. She's up here today. There she is. There's my Toots. But anyway, all right. So that's it. It's Friday. And I'm done with this nonsense for now. And yeah, I guess I'll smell y'all later. And as always, I